pipeline contractor has a $185,000 progress claim unpaid on an NSW water main project, while labour, excavators and delay pressure remain on site. The immediate question is whether to suspend work, terminate the subcontract or hold position while preserving legal rights. There are 4 key points to understand before taking action. First, suspension is often safer than termination. A valid suspension under the Building and Construction Industry Security of Payment Act 1999 is a temporary legally protected pause that can pressure the head contractor to pay without ending the subcontract. Wrongful termination is much more serious because it may expose the subcontractor to allegations of repudiation and claims for completion costs. Second, notice periods matter. Before downing tools, the subcontractor must serve a compliant written notice of intention to suspend under the applicable statutory pathway and wait at least 2 full business days after service. Walking off-site too early can turn a legitimate payment dispute into an allegation that the subcontractor abandoned the works. Third, unfair termination clauses are not always enforceable. A unilateral termination for convenience clause in a standard form. Small business subcontract may be challenged under the Australian consumer law if it creates a significant imbalance, lacks fair compensation, or is not reasonably necessary to protect legitimate business interests. The head contractor may need to justify the clause if it relies on that termination power. Fourth, insolvency does not automatically let a subcontractor exit. If the head contractor enters administration, ipso facto laws may pause a right to terminate based solely on that insolvency event. The safer approach is to identify and document separate defaults, such as missed payments, denied access, or failure to give directions. Before removing plant, sending a termination notice, or suspending work, get an early dispute strategy catered to your situation. Contact Merlot Law today.